Awesome. Hello, everyone. My name is Josh Kaplan. I'm one of the founding partners here at Vicente Sederberg, and I just wanted to thank you all for tuning in today, and for those who joined us last week, thanks for coming back. To build off of our great webinar we had last week with Burns and Levinson, we have another really fantastic webinar in store for you today. First, there's to provide a little overview, first of Andrew Livingston, our in-house economist and policy experts, going to give an update on the current state of the cannabis industry, both in terms of sales and also regulatory changes. Then we're going to go deep on employment law with the renowned international employment law firm Littler. We have Josh Kirkpatrick and David Gartenberg here with us today. And finally, we'll hear from our own Meg Nash, who's been diving deep into the CARES Act and sort of the federal assistance that's available and not available to cannabis businesses. And the one sort of key item to remember today is that this webinar is for you guys. It's for our audience, and so please ask questions in the chat. Ask those hard questions. Let's go deep. We want this to be valuable to you. And so how we're going to structure this is, we're going to take some questions after each speaker, and then we're going to, if there's time at the end, we'll take, questions at the end with everybody. So with that, let's get started. Andrew, you're up.
Thank you so much, Josh. Thank you so much, Littler, for joining this webinar as well. And thank you, Meg. Thank you to everyone listening. Really, looking forward to talking to everyone about what we're seeing so far when it comes to cannabis economics and the cannabis policy changes after this COVID-19 crisis. So, I'm going to be getting into first some of the state and policy responses to the COVID-19 pandemic, what we've been seeing when it comes to marijuana regulatory structures, the licensing agencies, as well as what we're seeing when it comes to sales. So first, let me start off with, we have been hearing a lot from businesses, from legislators, and really from governors across the country about whether or not cannabis businesses can stay open. This differs both for medical and for adult use. And predominantly, we've been hearing in the news about a term called, essential designation. Are you critical infrastructure? Are you essential? And this is strange, right? Because, many of us look at our jobs, look at the medicine we utilize, look at the substances that we buy from regulated cannabis storefronts, and we say, yes, that's essential to me. But is it really, what is quote unquote essential infrastructure? And so, to further kind of clarify what this actually means, I'm going to dive into where that term comes from. So that term has come from an agency called CISA. This is the Cybersecurity Infrastructure and Security Agency. And they put out in the middle of March, on March 19th, a memorandum on identifying essential critical infrastructures and workers during the COVID-19 response. And so the federal government laid out a number of different categories that they deemed essential. So healthcare and health infrastructure, banking, finances, and financial infrastructure, clearly, physical infrastructure, roads, buildings, bridges, dams, power and infrastructure of that sort, as well as, our agricultural commodities, and the supply chains that feed those critical infrastructure. So this wasn't, a strict list. Only the people that were, the types of businesses that were listed from the federal government could be included. This was essentially recommendations to states to put out similar sorts of lists identifying what they deem to be critical infrastructure necessary to stay open and stay operable during the shutdown. And that's exactly what happened. We saw states across the country adopt the same type of framework from this federal government list, from this CISA memo. And then they added cannabis or chose not to add cannabis into specific areas. And this is, again, where we've seen a little bit of a differentiation between medical and adult use. In almost every single medical cannabis state, we have seen dispensaries, cultivation, manufacturing, the supply chains which serve them, be designated as essential, typically under the healthcare and health services under kind of other healthcare. So things like alternative pharmacies, and then they would add cannabis dispensaries or compassion centers or cannabis manufacturers, medical cannabis manufacturers, whatever designation the specific state utilizes to basically reference its cannabis licensees. And so this is essentially very important to know, but it's also important to look at the differences between medical and adult use. In some cases, both medical and adult use are listed as critical infrastructure. That's the case in a state like California. In some states, there was a designation that was specific to medical cannabis dispensaries and adult use if certain things were essentially put forward by the regulatory agency to limit its use. So in Colorado, we had medical cannabis dispensaries and adult use for curbside. That had further clarifications that I'll discuss later on. And in some states, we've seen really first and foremost in Massachusetts, a designation of medical cannabis businesses to stay open, but adult use cannabis stores have been forced to close. And so that's some of the first changes we've seen there. And going forward, even despite continued shifts in policy, I think it's probably unlikely, unless things get dramatically worse, that we will see medical cannabis dispensaries close. And this is because governments are recognizing that they are essential. And it's also important to take a step back and realize where we are today. A decade, 2 decades ago, depending on which state you're in, medical cannabis and definitely adult use cannabis was illegal. It was a criminal act. And now governors, state policymakers, and even public health professionals to some degree are recognizing that these businesses serve an essential purpose for patients and consumers alike across the country. Both in red states and blue states, we're seeing many of the states move forward in a similar sort of way, recognizing that cannabis sales, particularly for medical use, are essential. So then the next question is, what are they doing to cope with these changes? In order to provide that cannabis businesses can still operate and operate safely. And so the first thing is they've established social distancing sales. And so what does this mean? So it really depends upon the specific state. And rather than providing specific slides that get into every single state and what they are doing, I'm going to talk about this generally. And the reason I'm doing that is because things are moving so quickly that if I were to send something out, it may not be relevant if you were to pull up this slide next week and want to reference it when speaking to a colleague or client. We have seen some of these policies move multiple times in a day in a specific state, and they're definitely changing weekly. So I think the first and most important thing to talk about is the emergence of curbside pickup. So in the past, we really only had 2 primary avenues for sales, 3 if you include caregivers picking up for medical patients. You had direct delivery. So that was, in a place like California or Nevada or others, delivery to people at their home. In other cases, you had just going to the physical store, going inside the licensed premises, inside their restricted access area, their sales floor, and purchasing cannabis on premises there. But now, since we are having real difficulties in ensuring that people can get their medicine while simultaneously keeping people physically distant from each other, states across the country have established curbside pickup. And this differs state to state. I'll give a little bit of examples between them. So in some states, you can engage in actual full-on transactions outside the licensed premises, typically on their parking lot or on the stoop, the walkway up to the building. And from there, you can transact in cash or credit, place orders and receive orders and pay for those orders as needed. That's, the case in a state like Washington. It depends upon where you're at in a state like California. And then in other states, there are kind of further restrictions. So Colorado, just a few days ago, came out with some further restrictions clarifying that you can place pre-orders, you can pay via debit or credit, but you cannot transact cash outside the licensed premises. And for those people that are allowed to go inside the dispensaries or inside the adult use stores, and this again will differ state to state, you have to maintain those social distancing. They will only allow, let's say, a certain number of people inside the store, and employees also have to stay apart from each other. And so this is important to recognize when you're creating these new standard operating procedures. And whenever the business is creating those SOPs, which are vital and in some cases, some states actually mandatory to create and electronically submit new SOPs, make sure that you're speaking with the attorneys, because this information is changing very, very quickly. And you don't want to be referencing old SOPs on or old requirements on how you're supposed to engage in sales transactions if new information has come out. Furthermore, we've seen in certain states expanded home delivery. So this is, in some cases, recommendations on the medical side to further roll out those delivery options. In other states like Nevada, they've gone to delivery only. Home delivery, while extremely valuable in a case like this, where we're all trying to socially distance, we have not seen a state that had otherwise banned home delivery start that process up. And that's probably because from a policy perspective, there's a lot more complications when it comes to that home delivery. So let's also talk about some new employee policies that we're seeing. And this is really valuable, as our next presenters will talk about from the employment side of things. But it is fascinating because there's a lot of nuances on employee policies. So, in some states, you have to be specifically registered for that business you are working at. So, in pretty much every state, you've got to apply to both the state and you've got to submit background checks and fingerprints. The state will process those, ensure that you don't have any excluding felonies or any other, excluding criminal offenses. And then you are licensed to work in a cannabis business. In some states like Oregon and Colorado, that means that you're licensed to work generally, and you can move from business to business. But in many of those states, you're actually assigned an employee card that references that license. And so that can create complications when a business may need to hire more staff because maybe there's a temporary increase in sales, and they need to account for that, or they have some employees that are sick and they need to build up their staff. And in other states, it could be a real problem where if you're an employee and a business has to shut its doors for a period of time because there was an outbreak, it's going to be harder for you to find work somewhere else. Furthermore, there are some innovative things, particularly in the state of Washington. So, when you're a cultivator or a manufacturer, this is a licensed premises, and pretty much in all states, you can't have anyone who's a minor on the premises because this is cannabis and it's a heavily regulated product at the state level. But also there's no child care and everyone's working from home when they can. So Washington State put out a really innovative policy that if you have a minor child under the age of 16, you can actually bring them on the licensed premises of a cultivation or manufacturing facility. As long as they're not touching any plants or doing any activities, and essentially they're, in a room being monitored by someone, essentially having a little bit of in-house daycare, but, you're a single parent, you've got to work. And so it's really, really nice to see state regulators recognizing the pinch that this has put us all in and creating policies to really provide for that. So let me talk a little bit about the long-term implications for the cannabis industry and the supply chain. And I'll reference this as it pertains to some information we're seeing. So, I wanted to bring up some sales as well. So this is looking at Massachusetts and Florida from essentially the second week of February, going forward to a write-up before and really, in the last week or two. So what we've seen so far is, there was general increases in sales, but really starting in the second to third week of March, we saw massive increases in sales. And that really followed from the same rush on grocery stores for toilet paper, for, food products and pastas. People went out to get their liquor and they went out to get their cannabis as well. And we really saw those stores get flushed, and a lot of businesses were talking about how they had higher sales than, in some cases, even 4/20 of last year. But since that period of time, we have seen some significant declines. This is possibly because we are seeing individuals already have the supply they need, and what they're doing is trying to, eat all their groceries, use all the toilet paper they bought, hopefully not, save it for in need over long-term time, as well as with their cannabis, but they're not going out and buying as frequently. And so we are seeing sales decline from that peak, both in Massachusetts and in Florida. And while one is an adult use state, one is a medical state, I think both are showing the same sort of structural dynamic. Furthermore, I saw an article this morning from MJ Business Daily using data from Headset, which is a seed-to-sale tracking and analytics company out in Seattle, Washington. And they had shown that, yes, in that middle week of March, both in Colorado, Washington State, and California, there was significant increases in sales. In California, 159% increase from the year prior. But since that time, things have dropped pretty considerably. And in the state of Colorado, over this last week or so, there actually has been about a 46% reduction in sales from the previous year at the same time. Now, why is this occurring? So in some cases, this may be because people have stocked up and they're just not going out to buy more because everyone's trying to stay in their house and, really, try not to interact with anyone else. The second thing is the impact on tourism. So while it's sunny outside, in Denver, this is peak time for skiing and for spring break. And so people aren't traveling anymore. All of that tourism money is not flowing in the same way. This will have a differential effect depending on what state you're in, and particularly will hit hard Nevada, as so much of its cannabis demand is dependent on tourism traffic to Las Vegas. Now let's talk a little bit on the long-term perspective for cannabis sales and the supply chain. This is going to affect cannabis businesses going on for really probably the next year or so. And that's not just because stores are going to potentially have to slow down the amount of sales that they have through their stores and physical individuals, and curbside may take a little bit of time to implement. But it's going to affect people going on for a while because investment is going to become more difficult. A lot of people are losing money right now, particularly those who hold large amounts of investment in the stock market. And further, people are losing their jobs in pretty considerable ways. And we may start to see demand decline as some people who were employed previously but have since been unemployed look to reprioritize some of their spending, really just focusing on rent, staples, and others. So while this will take a little bit of time to flush itself out, hopefully cannabis demand will persist. While possibly at slightly lower rates. We did see during the Great Recession, alcohol and liquor sales continued at a similar rate. So while there are good signs, there are also some bad signs going forward.
Thanks so much, Andrew. Very, very helpful. We have time, for one question. So I'm going to pick the first one from Jim Rice here in Colorado, and the question is there any movement at the MED to waive the badge requirements because they have a lot of non-badge employees that really want a job at their dispensary, and a lot of their badge employees that that don't want to work for on the front lines of this virus for a whole host of other reasons?
So while we have seen waiving some of the fingerprint requirements for ownership changes and ownership new applications for certain investors, we have not yet seen the Colorado Marijuana Enforcement Division waive requirements for employees. I have been in discussions with others, and there is a push to at least allow casino employees who are now pretty much all furloughed or not working because the casinos are closed to be able to work at a cannabis business because they've undergone a similar background check. Furthermore, Oregon has allowed businesses to begin accepting new employees once they submit their applications for background checks, but yet have not, gotten those specifically approved yet. Yet across the United States, I have not seen any state to fully rescind its background check or licensing requirements for employees.
Awesome, Andrew. Thank you so much. If you have more questions for Andrew, please, please put them in the chat, and we'll either get back to you one-on-one or, we'll save them for the end. Now I'd like to turn things over, to Josh and David at Littler to dive in deep on, some of the key employment issues that are facing employers, both in this time of uncertainty, but also with this federal stimulus bill, and also just, a lot of questions about what do, employers do with their workers who are on the front lines and who are scared of working. So I'll turn things over to you guys.
Yeah, awesome. Thanks so much, Josh, and thanks for having us out. David and I are both in the Denver office of Littler Mendelson, and I can tell you our practice has been quite busy advising employers on all of the issues surrounding COVID-19 in the last couple of weeks. One of the key issues that we keep hearing and getting questions about are these new federal laws concerning paid leave for workers and changes to the unemployment compensation system. So we wanted to start out with that. The Families First Coronavirus Response Act is the federal law that created two new types of paid leave for employers and employees. This was passed a couple weeks ago. The FFCRA has two key components. The first is emergency paid sick leave. That's up to 80 hours of leave, so 2 weeks. There are a number of different reasons people can obtain that leave. And depending on the reason for leave, that's either paid at an employee's full rate of pay or at 2/3 of that rate of pay. Again, that's the first 2 weeks. After that, there is emergency paid FMLA. Many of you, particularly those of you that work for employers with 50 or more employees, are probably familiar with the Federal Family and Medical Leave Act. There are a number of very significant changes, so it's not the same rules as the FMLA. The emergency paid FMLA, or FMLA Plus, provides for up to 12 weeks of leave, but although the first 2 weeks are under the emergency paid sick leave, it pays out at 2/3 of an employee's regular rate of pay, subject to some statutory caps. And this was not just the federal government sticking it to employers, forcing them to pay for these leaves that might otherwise have been unavailable. The federal government has said that there will be tax credits on the back end for employers who are required to provide these two types of leave. All of the monies paid out can be obtained through tax credits on the back end. With respect to the emergency paid sick leave, that is the first couple weeks, covered employers. This law only applies to employers with fewer than 500 employees. The congressional intent there was that bigger employers with 500 or more employees probably already had some type of sick leave or PTO or vacation that was available to employees in these situations. So this law only applies to folks with fewer than 500 employees. That's led to a lot of questions from employers about how you count that 500, and specifically what we refer to as the integrated employer test. Whether you've got two related entities, are they the employees of both counted for purposes of getting to this 500 employee threshold? And there's a 4-factor test looking at interrelation of operations, common management, centralized control of labor relations, as well as common ownership that you look at in terms of determining whether someone is an integrated employer. I think the key here, I think a lot of employers are jumping to say, okay, we are integrated employers, so we've got 500 employees, so this doesn't apply to us, but they may not be looking at the long-term ramifications of that. So I think there's 3 inquiries here. Are we required to provide the leave? If we do elect to provide the leave because we say we're not an integrated employer, are the tax credits going to be available on the back end? And finally, are you creating some unintended consequences with respect to other issues? For instance, you say we're an integrated employer, so we don't have to comply with the FFCRA. Is that going to influence, for instance, a company's labor relations strategy? If a union comes in and says, you said that you were all one big happy company, now we're going to try to organize the whole company, even though historically you've had different divisions operating with separate management. The second question there, who is an eligible employee? Easy answer to that one, everybody. Everybody's eligible on day 1 of employment for the emergency paid sick leave.
So I'm going to talk a little bit about what types of categories of employees are actually able to take this emergency paid sick leave, because it's a little bit more limited than I think a lot of people have in their heads. I saw one of the questions that was asked during this presentation was, what if you do if an employee just doesn't want to come to work, doesn't feel safe coming to work, but might not be exhibiting any symptoms of COVID-19, or it could be perhaps we're getting a lot of questions like this, where somebody says my spouse, the person that I live with, is immunocompromised, so I'm really extra specially concerned about contracting the COVID-19 virus, so I don't want to come to work for that reason. And that can be a determination that you still want to make with the employee to see if that's something that you want to accommodate, but it's not something that's covered by this new federal law, the FFCRA, and specifically for the paid sick leave component of it. There's just 6 reasons that you can take paid sick leave under this statute. And the first part for each of the 6 reasons is that you are unable to work, or you're unable to work from home, or telework is what it's called in the statute. If you are able to work from home or are an essential business and are still able to go to the workplace, then you probably are not going to qualify for this. But if you're unable to work for any of the following reasons, then you do get this 80 hours of paid sick leave, 2 weeks of paid sick leave. The first is if you are actually subject to a quarantine or isolation order, like from the government, if you've been directed to quarantine in your house because you've been told that you have been exposed to the COVID-19 virus, then you might be covered. However, if you're still able to do your job, to telework from home, then the person would not be eligible for this credit because they were still able to work. Being unable to work is a precondition to taking this leave. The second category is if the employee is advised by a healthcare provider to self-quarantine because of COVID-19. That one we're seeing a lot more of, because a lot of times people might have some mild symptoms. They call up the doctor says, you don't have severe enough symptoms to get one of these prized tests that are in such short supply these days. So we're not going to test you, but you do have the symptoms. So we are going to, I'm directing you to self-isolate. I had a client the other day where their doctor said, an employee's doctor said that, I am so certain that you have COVID-19 that I'm not going to test you. So you need to stay home for that reason. So it can go in both directions. That person would qualify for this emergency paid sick leave. The third is that they are actually just experiencing the symptoms and they're seeking a medical diagnosis. That's a big catch-all there, because as we all know, it's a lot more difficult to get in to see doctors these days because everybody is completely underwater with this pandemic. So if the employee can certify to you both that they, have a fever and a dry cough or the like, you can look at the CDC website for what the actual symptoms of COVID-19 are, and they say, I am seeking a medical diagnosis. They don't have to actually have obtained it yet, but they're trying to get one, then they would qualify for the emergency paid sick leave. And the idea behind that is this is supposed to incentivize employers and employees to stay home if they could potentially spread this virus. And this is an incentive right here. If somebody is, taking the right steps, they're being proactive, they recognize that they have some symptoms of this of the virus, they're going to get to stay home and get their leave paid for 2 weeks. Those are the first 3, and those relate to an employee's own condition. The next 2 relate more to if they're caring for somebody else who might be exposed to it. So the first one, number 4, is they're caring, as I just said, for somebody else who's basically in items 2 or 3, or 1, whether the employee is, or the person that they're caring for is subject to an isolation or quarantine order or had symptoms of the same. And the 5th is a big catch-all now, because as we all know, many jurisdictions, almost all jurisdictions in the United States, are now under shelter-in-place orders. Many school districts are closed. If an employee is unable to work because they're caring for a son or daughter whose school or daycare facility is closed, or their regular childcare provider is unavailable for COVID-19 reasons, and the person is still unable to work, then that person could also qualify for this 10 days of paid sick leave. For example, right now, I'm in Denver. My kid's daycare is closed, so I am staying home. My wife is home as well, and she's not working right now. So she's watching the kids. I am still able to work. So I would not qualify for this leave because I don't still meet the first precondition that you're unable to work. If somebody else is able to watch the kids, you're able to work. we're going to talk about this a little bit more later, but if you're still able to get your job done, but have sort of a modified work schedule, if you can, do 4 hours in the morning and then take a couple hours on while you're watching the kids, and then take a couple hours back working once the kids go to sleep, you still would not qualify for this leave because you're able to work, but just under a slight modification. And the last one is sort of a catch-all for whatever is going to happen in the future. It basically allows the Secretary of Health and Human Services to designate new categories of reasons that people might be able to take leave for. But right now, that doesn't really apply.
Yeah, while David's advancing that slide, I want to jump in. I'm seeing a lot of questions about the availability of the tax credits and SBA loans to cannabis industry entities. Everybody, give us 10 minutes. I think Meg's going to focus on that piece of the of what you're all curious about.
Correct.
I know everybody that's everybody's. How do I get the money? I understand that being a common question.
I will interrupt. There is one interesting question about, on the last slide on item number 3 is, can you set a time frame to require a physician's note or medical diagnosis? Or in other words, can the employee perpetually seek a medical diagnosis but never get it?
So it's a really good question. Josh and I in a few minutes are going to talk about some frequently asked questions that the Department of Labor has answered. They've answered about 60, almost 60 of these questions right now. And I guarantee you that one of the questions has been that exact same one, but they have not answered it, is what exactly does this mean to be seeking a medical diagnosis? So we don't know with a lot of clarity exactly what this means. Under the, if you're seeking FMLA, there's a set time frame for returning like a certification. We know that they did not import that requirement expressly into this Family First, this special emergency paid sick leave provision. So we're not sure exactly how much time it is. What I would say is, I think saying like return a note within 7 days of when you believe that you're having a diagnosis would certainly be reasonable. I would also say that sort of loosening the requirements of what you're going to be asking for from the doctor might make some sense. For example, it could just be like a jotted off note from the doctor saying, I saw this person, I recommend him being quarantined, instead of requiring them to fill out like a certain form that the employer is going to be providing, because that could just slow down the process a lot of times. I don't know if Josh has some other thoughts on that.
Yeah, I'd say be mindful of 2 things. One is the increased prevalence of telemedicine here, that you're getting emails and things like that rather than the traditional doctor's note. Also be mindful of what's going on in your particular state or city, particularly with respect to recent amendments to paid sick and safe time requirements. I was looking at this yesterday, and San Francisco and San Diego have suspended the requirement for an employee to bring in a doctor's note, because I've seen a lot of clients who are having employees come to them and say, I can't get a doctor's note. I can't get in to see a doctor right now. So, you want to be mindful of that fact. And if you do have a situation where you feel like an employee is abusing the system, then you may be in a better position to require something quickly. But where you've got an employee who's telling you, I'm trying to get a medical diagnosis and I'm just not able to, I think err on the side of being accommodating.
All right. I think we've touched on a lot of these issues in the big picture, but I want to talk a little bit about what exactly it means to get this paid sick leave. First of all, if people are working, if they're full-time employees, they get 80 hours. They're working 40 hours a week. You get a maximum of 80 hours under this provision. So what I mean by that is, if somebody is working 40 hours one week and 50 hours the next week, they're still only going to get 80 hours total of paid sick leave. If they're only working 30 hours a week and 30 hours the next week, they're only going to get 60. It's not like they get topped off because, because of this law. The second piece of this is what do we do about part-time employees? How do we calculate the amount of paid sick leave that they are going to get? For part-time employees, the way that it generally works is they would get the average number of work hours that they work in a 2-week period. If they consistently work 30 hours a week, then that's a very easy analysis. If the schedule varies, if they have a varying work week and it's not nearly as consistent, then what the regulations provide is that you basically look back over the last 6 months and see how much the employee worked on average over that 6-month period, and use that to determine what their weekly rate of pay would be. And if they haven't worked for you for 6 months, then you just look at the amount of time that they have worked for you and average it over that period. The last piece is, how much is this going to be? Josh had mentioned earlier that there are caps on the amount of what the paid sick leave is. If you're taking leave for yourself, if either you or the employee is sick, is under a quarantine order, or has symptoms, they get 100% of what their regular rate of pay is, capped at $511 per day. So that's $5,110 over the 2-week period. If it's they're taking leave because somebody else in their household is sick, or because their kids are homeschooled, it's capped at $200 per day. It still would be, and it's 2/3 of their regular rate, not their full rate of pay. The last piece is sequencing of the emergency paid sick leave with other categories of PTO that employees might have accrued. The law is very clear that this sick leave needs to come first, and it's not like you can top it off with other sick leave. This sick leave needs to come first, or the employees at least need to have the option of taking this sick leave first. So you can't say, hey, you need to take your accrued vacation days, and then after that you can take this emergency paid sick leave. The sick leave absolutely needs to come first. The other thing is that if let's say that the employee would actually rather take the PTO because they would get, the emergency paid sick leave is subject to the cap. It might be only $200 a day, and employees might make more than that if they are using the other accrued PTO. What they could do in that situation is use whatever amount they would be getting, the $200 from the emergency paid sick leave, and then top it off so they're still getting a full day's work with whatever the amount of PTO that they have accrued would be. That's something that the Department of Labor has expressly said is fine to do. The last piece of it, though, is we've talked about the tax credits a little bit. If you do that, you're only going to get a tax credit for the amount that was subject to the emergency paid sick leave. It's not like if you give them more than they would be entitled to under this law, that the employer is going to get reimbursed for that amount or a tax credit in that amount from the government. You only get back the amount that you were obligated to give under this law.
That's right. Shifting gears over from the emergency paid sick leave to the Family and Medical Leave Act Plus leave. Again, same covered employer, anybody with fewer than 500 employees. There is an eligibility requirement with respect to the family and medical leave that someone has to have been there for 30 calendar days, but that's it. All of the FMLA rules that you're used to, 1,250 hours of service, 50 employees within a 75-mile radius, none of those apply with respect to this enhanced FMLA leave. We mentioned the first couple weeks are unpaid because that's when you're getting paid through the emergency paid sick leave program. Then there are 10 additional weeks that are paid at 2/3, just like David just described. 2/3 pay, maximum payment of $2,000 per day. You stretch that out 5 days a week times 10 weeks, and you get to a $10,000 cap on what you can be paid. There is a note here, I think a lot of employers saw this passed before the DOL issued any guidance and said, oh my gosh, do we have to give everybody effectively like 12 weeks of severance pay if we lay them off or if we furlough them? Those have been some of the questions that have been addressed in the FAQs that David mentioned. We're going to have a website where all of our articles are flash up here in a few slides. And one of the things we've done is broken down those DOL FAQs that have come out in 3 separate tranches. So we've got a lot of resources available to you explaining these issues more. Things like, how do you calculate it? What type of documentation? What happens if I close my facility? What happens if I furlough an employee or lay that employee off? Are they still entitled to these? With respect to those last questions, if an employee is furloughed, they're not eligible for this leave. And if an employee is laid off, they're not eligible for this leave. Again, those answers are out there, and they're both on the DOL website as well as our coronavirus launchpad site. One other website you'll want, and you could navigate to this through the Littler website, but I would suggest the easier thing to do is just to Google, DOL COVID poster. There is a poster that is required to be posted in workplaces that are open. If your workplace is closed, such that you've got employees working from home, then there's a requirement that you distribute it either by emailing it to employees or by posting it on your intranet page, if that's a way that you normally disseminate policies. But there is a federal poster that's required to describe these benefits to employees.
So Meg is going to be talking in a lot more detail about some of this, but the second big piece of federal legislation that passed recently is the CARES Act. This just passed about 5 days ago. Massive bill, huge amount of stimulus and money, the largest stimulus in American history. It's about 900 pages long, so there is a lot of information in there. And the key provisions for companies are a number of different categories of loans, emergency relief and taxpayer protection, some tax credits that you can get, and deferral of payroll taxes. We're going to defer talking about that for a little bit, but the one piece that Josh and I did want to talk about is a significant change to both the amount of unemployment compensation that is eligible to employees and terminated employees, and also people who are eligible for those categories of unemployment insurance.
Right. It's been, again, you saw the slide, this extra $600 that was on the first slide. David mentioned another enhancement is making unemployment compensation available to a lot of workers who wouldn't have been eligible in the past. Normally, employers, you've got an unemployment contribution that you make for workers based on the amount of money that they get paid. This and only those people for whom those pay-ins have happened are eligible for unemployment. Unemployment eligibility has been expanded to gig economy workers, independent contractors, employees of religious institutions, a bunch of folks who couldn't get unemployment before can, and now they're getting a lot more.
And the way that this generally works is however much employees would have gotten, or former employees, laid off employees would have gotten in state unemployment insurance, you can just add the number 600 to that. And that is how much people are going to be getting now. The average amount, I think, across the country, because it's different state by state, but the average weekly unemployment benefit used to be $500. It's now $1,100. So it's more than doubling the amount of unemployment insurance that employees can theoretically get. That also means that it's possible that people might even get more money if they are terminated and eligible to get this unemployment insurance than they would get if they were seeking leave under the paid sick leave or the Emergency Family and Medical Leave Act. The second big major change is that they've also opened up the categories of people that can be eligible for unemployment insurance. First of all, there's the gig workers, the independent contractors, but beyond that, the actual job action that needs to have been taken is far broader. So, for example, if somebody is not able to work because that individual has COVID-19 symptoms, that means that they could actually just quit their job and not and be eligible for unemployment insurance, which is a huge change from the way that this used to be administered. It used to be if you voluntarily quit, unless you were like constructively discharged, then you would not be eligible for unemployment insurance. But the fact that they are now significantly broadening this is opening it up to broad swaths of people who would not formerly have been eligible for unemployment insurance. A lot of the rules on how this is actually going to come out are going to be an interplay of states themselves interpreting this and the federal government giving more guidance, which they have not done yet. But that is basically the lay of the land in terms of unemployment insurance as of now.
Yeah, that's great, David. Thanks. And I don't want to steal too much of Meg's time. I do think one of the key things that the CARES Act has done in the enhanced unemployment is given well-meaning employers more options, right? I've had a lot of conversations with employers, times are tough. We don't need these people. We're really reluctant to lay them off. And this unemployment enhancement has really given them a backstop to know that those workers are going to be okay if they're laid off permanently, if they're placed on a furlough, right? We're getting a lot of questions from employers. We don't need this person now, but we anticipate when things pick back up, we will need them again. So a lot of employers are pursuing furloughs where an employee is effectively out of work for a month or 2 months, which who knows how long that's actually going to be at this point. Oftentimes an employer continues to pay the employees' health premiums and keep them on the employer's health plans. We're also seeing employers looking at across the board pay cuts. We're seeing information about job sharing, which frankly has become less of an issue due to the enhancement to unemployment comp, because rather than feeling like, boy, we'd like to keep people around even if they're only making half as much as they were, it's easier just to furlough some people or lay them off temporarily and allow them to obtain unemployment. I mentioned before, we've got a website here, littler.com/coronavirus, that I don't know how many, but 50 different publications that we've put together in the last couple weeks dealing with this. We've also got recorded webinars going into much greater detail than David and I just did on these programs, as well as all the other issues facing the employment piece of this COVID-19 pandemic. We've also got some toolkits available to employers, things like if you've got an exposure in the workplace, what does your exposure plan look like? What do the communications coming out of that exposure look like? Sample documents that you can use, as well as with respect to the FFCRA, sample policies and sample forms for employees to say, I need this emergency paid sick leave, I need this FMLA plus leave, and using those appropriate forms will be a key piece of getting the tax credit on the back end. With that, I'll invite any other questions. Otherwise, again, I hate that we've stolen some of Meg's time, and I don't want to take any more unless anybody has any critical questions. Otherwise, David and I are always available. We're not hard to find online, so if you do have questions, feel free to reach out.
Josh and David, thank you. Thank you so much. One quick question, and then we'll turn over to Meg. Is we've had a lot of our clients have employees, at retail locations, are interacting with people, and a lot of employees don't want to come to work. And how are you guys advising other ones of your clients that are in the grocery store space or other sort of like retail essential business spaces? And is there like some quick pointers people should think about?
David, you want to take this? I know you've had a couple of those lately.
Yeah. So one of the things to keep in mind is that even if a business is exempt from a shelter-in-place or a stay-at-home order, most of those orders still either require or strongly urge the employers to make sure that they're following the CDC guidelines and social distancing requirements and the like. In grocery store settings, for example, I know that grocery stores, a lot of them are like basically shutting down for like 10 minutes every hour or two and just sanitizing everything really quickly. I have a client that has a factory that is in the essential or a manufacturing plant that's in the essential exempt employees or employers sector, and they are making sure that everybody is spread out 6 feet away from each other to maintain social distancing, and are actually putting like electrical tape down on the floor to make sure that people are complying with that. So that answers half of your question, is like, what do you do to make sure that people are still safe? The second half of the question, and those are the things that you can do, and similar things, and you can be creative about this as well. The second part of the question is, what do you do if employees still don't feel safe coming into the office or into the retail sector for whatever reason? And that is really a question that, as long as you have already taken steps to make sure that the workplace is safe and you're following all the CDC guidelines, from an employment law perspective, you've done everything that you're obligated to do. Then it becomes a question of just like, how do you want to deal with this person individually, and what kind of precedent do you want to set here? So you could certainly say, you can take an unpaid leave of absence, or you can start drawing down your PTO if you don't feel comfortable coming into work, and I'm not going to take corrective action against you. Or you could say no, and say, I'm sorry, we've done everything that we can, and we need you here. You're in an essential business. It's in some ways it's as important as ever that you do your job. So it's more of like an employee relations type of situation.
That's right. And I'd say be mindful of state law here too. I know Oregon, for instance, has a provision in its paid sick and safe time law that says, like, if an employee doesn't feel comfortable coming to work because of COVID-19, then they can take that state mandated sick leave to deal with that situation. But everything David said is absolutely correct from a 50-state perspective, but don't forget about state law.
Yeah.
Awesome. Well, thank you guys so much. For those listening, please, it sounds like you definitely need to consult your employment attorney. And if you don't have one, feel free to reach out to Josh and David at Littler.
Thanks so much, Josh.
Thanks. And, now I'd like to bring Meg on to sort of answer some of the fundamental questions around here of, if there is answers, it's like, how does the CARES Act, is it available to cannabis businesses or hemp businesses, and what about these tax credits? And and so I'll sort of turn it over to you, and we don't have the most time, but
thank you, Josh. Yeah, I appreciate it, and thank everyone so far. My co-presenters, this has been hugely informative already. As Josh mentioned, I think what is on a lot of people's minds is, how do I access some of this small business funding that has recently been made available under the CARES Act? A couple provisions I want to highlight while we have time is the Paycheck Protection Program and the expansion of the Economic Injury Disaster Loan Program. There's also a $10 billion funding available through an emergency grant program, which will allow small businesses, nonprofits, and agricultural cooperatives to request an emergency advance loan of up to $10,000 against an economic injury loan, with no requirement to repay that advance. In addition, there has been specific funding diverted through the U.S. Department of Agriculture and other programs that may be accessible for our hemp clients. So that's a very, very brief overview of a very lengthy and involved bill. But for purposes of small business owners and immediate access to funding, these are sort of the primary programs that are going to provide an avenue for some relief in these sort of unprecedented times. I'll slip over these first few slides just so we can get into the meat of the Paycheck Protection Program and Economic Injury Disaster Loan Program a little bit. But I do believe that these are available, and I'm certainly happy to provide more detailed information to anyone who may need it in terms of sort of digging down into each of these programs. So the first question, especially for our cannabis company clients who are directly involved in the space, is, am I eligible for SBA loans? Is this something that I can access? It's great that the federal government has done this, but what does it mean for me? Which is exactly the right question you should be asking at this point. Unfortunately, for individuals who are operating licensed cannabis businesses, such as dispensaries, cultivators, product manufacturers, it's unlikely that they're going to be able to access funding available through either the Paycheck Protection Program or the Economic Injury Disaster Loan Program because of the illegality under federal law. So far, the SBA has the SBA being the Small Business Administration, has proactively confirmed that marijuana businesses are not able to access the Economic Injury Disaster Loan Program. While we haven't seen such an affirmative statement from the SBA with respect to the Paycheck Protection Program, it does appear that prior policy guidance would prohibit access to cannabis companies. Specifically, there is a 2018 policy notice where the SBA clarified that marijuana businesses and even non-plant touching entities who service the marijuana industry cannot receive aid in the form of federally backed loans because financial transactions involving a marijuana related business generally involve funds derived from illegal activity. So in addition to that prior 2018 policy notice, which we can, rely on as some guidance of what the SBA might do here. The application itself for the Paycheck Protection Program seeks certification from the applicant. They are not engaged in any activity illegal under federal law, which licensed cannabis entities would, be unable to truthfully attest to, given the marijuana's federal illegality and the scope of their operations, even though it's legalized under the state. I will say, as sort of a glimmer of hope, there is a lot of advocacy happening at both the state and federal level to try to create a specific carve out for cannabis businesses. But this is the current state of the law as we understand it, although we do anticipate further guidance going forward. For ancillary businesses, the inability to access funding may extend to them as well, but eligibility is really going to have to be assessed on a case-by-case basis and can turn on a lot of sort of various factors that, again, myself or other Vicente Sederberg attorneys would be happy to work with you in terms of sort of making a determination with respect to application for the Paycheck Protection Program. There does seem to be much more viability for access to funding for hemp businesses. The SBA has clarified that businesses that produce or sell hemp and hemp-derived products that are legal under the 2018 Farm Bill would be eligible for SBA loans. So with that in mind, let's get into a little bit more details about what the Paycheck Protection Program and Economic Injury Disaster Relief programs are. Under the Paycheck Protection Program, businesses with fewer than 500 employees are eligible to apply for loans. The borrower is not required to provide any collateral or personal guarantees for the loans, but they must certify that the loans will be used for payroll costs, costs related to the continuation of group healthcare benefits, employee salaries, mortgage and rent payments, utilities, and interest on other debt that was incurred prior to February 15th, 2020. So there is sort of a broad category of things that funds from this program can be used for, but at the same time, it's limited. It's not a blank check that can be used for any sort of business operating expense. It must be within that category. There are some limitations on the loan amount. It must be the lesser of 10 million or 2.5 times the average amount of payroll costs in the year prior to when the loan is made. So again, that's going to vary from business to business as to what the loan amount can be, but is sort of within those parameters. In order to apply, businesses have to go through a third-party lender that's approved by the SBA. And we do have some information up on our website providing access to the SBA lender match. Because these are loans that will be administered directly through third-party lenders as opposed to the SBA itself. Different rules apply with respect to the expanded Economic Injury Disaster Loan Program. Although similarly, it's also businesses with less than 500 employees that are engaged in legal activity that have experienced economic harm who are eligible to apply. And again, the congressional intent behind that is sort of thought that bigger corporations would be able to sort of perhaps weather this a little bit differently. Unlike the Paycheck Protection Program, collateral is required for loans over $25,000 and personal guarantees are required for loans over $200,000, but borrowers can receive up to $2 million. And these loans must be applied for directly with the SBA as opposed to a third-party lender.
And Meg, I'm just going to interrupt you for 1 second because I know we're coming up on the hour, and and we can go longer, but we're going to start to have some folks drop off here. I did want to say that this Friday we will be having a webinar with our good friends at Burns and Levinson, diving in even deeper into the SBA loans, to the Paycheck Protection Program, how to apply, what the application looks like, strategies to get at the front of the line. So stay tuned. Everyone who's on the webinar, check your emails and join us next Friday. And for those who do want to, who can stick around for a little bit longer, we can take a couple more questions and make you go a little bit farther. But I just want to do a short little plug before the end of the hour.
Yeah, absolutely. So again, this has sort of been a very, very high level review of Paycheck Protection Program and the expanded Economic Injury Disaster Loan Program. But these provisions are accessible primarily to hemp businesses. Yeah, it's a yes for hemp, a maybe for ancillary, and at this point it seems like a no for cannabis businesses, although there is efforts in place to change that. I also want to highlight the fact that eligible businesses may be able to borrow under both the Paycheck Protection Program and the Economic Injury Disaster Loan Program, provided that they're not used for the same expenses. For example, under the Economic Injury Disaster Loan Program, those loans can be used for different type of costs, such as costs related to paid sick leave, also used for maintaining payroll or meeting increased costs as a result of interrupted supply chains. So, you may be likely to run into issues if you're trying to get a loan under the Paycheck Protection Program for payroll costs and under the Economic Injury Disaster Loan Program for payroll costs. But to the extent that they're for different purposes, there doesn't seem to be any indication at this point that you wouldn't be able to access funding under both programs. For hemp businesses specifically, in addition to general loans and tax and other benefits that we've discussed already, there are specific provisions that are specific to the agricultural sector. There has been $9.5 billion earmarked for the Department of Agriculture for agricultural producers, $14 billion to commodity credit corporations, $20.5 million of lending for USDA's Rural Development Business and Industry Loan Guarantee Program, as well as a temporary 3-month extension on repayment of commodity marketing assistance of loans from 9 months up to a year, in addition to $100 million in grants to improve rural broadband. These loans fishes may be used for essential business purposes, including business acquisitions, construction, conversion, expansion, repair, modernization, and development, as well as for refinancing loans, as long as the refinancing improvements provide cash flow while creating or saving jobs. So this has been a lot of information sort of thrown at everyone underneath a very, very expansive federal program. But I wanted to sort of give that high level review for our clients who are in the cannabis, ancillary, or hemp sectors to just let you know as to what is available out there. And certainly we're able to provide more detail in navigating this space in terms of getting relief for your businesses and assistance with your employees. I will just mention before I end or take some more questions that there are additional payroll taxes or tax credits that may be available as well. It sort of, again, remains to be seen whether or not these are programs that cannabis industry clients would be able to take advantage of with respect to 280E. And we are consulting with, CPAs and tax consultants to get further clarification on that, which is ultimately likely going to come down to whether or not the tax credits are related to the trade or business of trafficking in a Schedule I substance, which may depend on sort of fact-specific patterns with respect to each client's business operations. So again, please reach out to us if you have questions in that regard, and we'll be able to provide further guidance.
Awesome. Thank you so much, Meg. That was a lot of information and, in a short time. So, definitely thank you. I want to capitalize on sort of one thing, that you said in terms of the tax credits is, we have been, talking with different tax attorneys from Henry Rukowski to Nick Richards to different CPAs, Code Resnick about whether the payroll tax credits, can be deducted or whether that deduction is going to be prohibited by 280E. And, right now it's, we've talked to 3 different people and there's been 3 different answers. So, happy to sort of like discuss details, with anyone individually, and also happy to, make referrals or have conversations with them and, and their tax professionals. A question, Meg, you've hit a lot of the questions, and just to sort of, we asked the final one. It's like, so where we are, with the payroll protection program and cannabis businesses, if someone thinks they qualify, what do you recommend they do? Who should they reach out to?
Well, certainly they should consult with an attorney to sort of touch base in terms of their scope of operations, who would be able to provide further guidance. But a lot of this is going to come down to third-party lenders as well, who will be responsible for administering the Paycheck Protection Program, who would likely be able to provide more guidance about access to funding. Ultimately, that's kind of the gate that you need to walk through in order to access funds. I think that, to the extent that you have your cannabis business has a positive relationship with a financial institution and can reach out to someone there to provide sort of further guidance in any directives that they may be getting, that would be a valuable resource. And certainly we will continue to be updating our website as additional regulations and guidance come out with respect to these programs.
Awesome. Thanks so much. Really great advice. Talk to your financial institution and, your bankers about, whether they're participating and, sort of more of the nuance and details around there. And then, of course, if you have questions, feel free to ask us at Vicente Sederberg, ask our great friends at Littler. And so, I just want to thank everyone who joined us. All apologies if, for running a little bit late. Check out our website and stay up to date on these issues. Check your emails. We will be having another webinar on Friday with our friends at Burns and Levinson about, really diving into the CARES Act and the SBA loan. So, thank you all and look forward to seeing you all soon.
Thank you.
Thanks, everybody. And thanks to you, Josh, for inviting us to participate.
Thank you, guys.